important that you take into consideration generally how you should structure a problem question. Most of the law students are aware of the IREC structure, however, it is rarely followed accurately. You should take into consideration that by stating the issue in your answer of a problem question, it doesn't mean that you need to copy and paste of the facts of the case. You never copy and paste facts of the case. You do not need to put an introduction in an answer to a problem question. Issue means a legal issue that is at hand. For example, a statement of issue can be, it shall be discussed if duty of care exists. This is a statement of issue. It should be one sentence. It should be really briefly stating what is the legal issue that you are going to address, not copy and paste the facts of the case given to you. Afterwards, after the statement of the issue, you need to discuss the rule. The rule is the law that applies to the facts of the case. It should not be explanatory. In other words, you should not dedicate most of your essay in explaining what is the law. So if you have a question about a problem question about negligence, your problem question should not be explaining the laws on negligence entirely, but it should be only explaining the relevant laws, the relevant laws to the problem question given to you, and then applying it to the facts of the case. Explanation of the law should be probably 50% of the answer, and the rest of the 50% should be the application analysis. This is where you demonstrate your legal knowledge, and this is where you get your marks. So if you omit that part, you will most likely get below 40. Essay question is written a bit differently. Essay question, you should also state the issue that you are discussing and the relevant laws, but instead of applying it to the facts of the case like you usually do in a problem question, in an essay question, you have to refer back to the question and make an argument to answer the question asked. Most of the times when I read the answers of students, the issues that I see is that the argument is not clear. They usually explain the law applicable to the essay question. For example, if they see an essay question about duty of care, they understand it like if they had to write everything they knew about duty of care, but that's not the way to do it. You need to answer the question asked, and most importantly, you need to make an argument. For example, if the essay is asking you about duty of care, it should be giving you a specific direction for research. For example, it can tell you the essay question on duty of care can be something like if breach of duty is still a requirement to establish a case of negligence. Like you need to, in this kind of essay question, you need to provide arguments for and against the statement given to you, rather than just write everything you know about the concepts that you see in the statement of the essay question. Negligence is the breach of duty of care owed by the defendant to the claimant, which results in damages to the claimant that is not too remote. So we have 4 elements of negligence: breach of the duty of care, breach of the duty of care, and remoteness. The most important element that we're going to discuss now is duty of care. Duty of care traditionally was automatically assumed if we had one of the following scenarios. If it was the parties in the case were one road user and another, solicitor and a client, doctor and a patient, manufacturer and consumer, and employer and employee. Duty of care for employer and employee liabilities is also called vicarious liability. And the starting case for duty of care is Donoghue and Stevenson. This is where the duty of care principle was established. However, today, the law on duty of care is a bit different than it used to be before, and we're going to discuss exactly how duty of care was first established in Donahue and Stevenson, what were the main principles back then, what has changed after that, and how did the law develop. In Donahue and Stevenson, neighbor principle was established. It was generally recognized as beginning the process through which a general tort of negligence emerged. One must take reasonable care to avoid acts or omissions which one can reasonably foresee would be likely to injure their neighbor. So as you probably can remember, Donahue and Stevenson was the case about a person who was who bought a beer, and this person found a snail in the beer. And the problem here was that they couldn't establish a duty of care because the person did not buy the beer from the manufacturer who was selling this beer, but the person bought this beer from at the bar. So there was no duty of care between the consumer and the manufacturer. So that's why, in order to find a duty of care and to find the manufacturer liable for this tort, they had to invent this principle called neighbor principle, so that the manufacturers were liable for any negligent acts that can injure the people that may be consuming the goods that they sell. So the neighbors are persons who are so closely and directly affected by the act of the defendant that the defendant ought to reasonably have them in contemplation as being so affected when the defendant was directing his or her mind to the acts or omissions which are called in question. In this case, the manufacturer who is producing the beer, they had to take into consideration that if someone who consumes their beer finds a snail in it, that they may be injured, they may suffer, so the consequences may occur. So there was a duty of care and the connection between the manufacturer and the consumer of the beer. However, in order to limit the liability and not like establish a general duty of care of all manufacturers to the consumers, they had to establish a test, a specific test that had to be applied. It's called Ann's test of duty of care, and the trend started towards generalization in the tort of negligence in Ann's versus Merton, where Lord Wilberforce expressed a universal test which would determine whether a duty of care is owed. So it was no longer automatically assumed if there was an established duty scenario, but a test, a specific test had to be applied to determine if there was a duty of care. Two-stage test by Lord Wilberforce in the case of Anne versus Merton was the following: whether as between the alleged wrongdoer and the person who has suffered damages, there has a sufficient relationship of proximity or neighborhood such that in the reasonable contemplation of the former, carelessness on his part may be likely to cause damage. So some kind of carelessness had to be shown, and sufficient relationship between the parties involved, proximity. And the first question, if answered affirmatively, it was necessary to consider whether there are any considerations which ought to reduce or limit the scope of the duty or the class of persons to whom this is owed, or the damages to which a breach of it may give rise. So this case, Anne versus Merton, limited the scenario, the situation where duty of care could be established, because it beforehand it opened the floodgates of liability. Too many cases were received about this matter, and they had to put some control of duty of care, and some sufficient relationship of proximity had to be shown in order for duty of care to have been established. The problems with the test were that negligence law was likely to expand into unpredictable areas. The range of situations in which one's negligence is foreseeably likely to cause harm is very broad indeed. So it was still broad, it still needed more control to not open the floodgates of liability. So further development of the test was needed. The next stage of development of duty of care test we saw in Caparo. Caparo was the three-stage test that applied in order to determine if there was a duty of care. Could the defendant have reasonably foreseen that his or her negligence would harm the claimant? Is there a sufficiently proximate relationship between the claimant and the defendant? And is it fair, just, and reasonable to impose a duty? So as you can see, these were the three questions that had to be answered affirmatively in order for the duty of care to be established. However, as you can probably see, the third question is very controversial. Is it fair, just, and reasonable to impose a duty? It was very hard to determine what is fair, just, and reasonable without some further guidance on this area. So the next stage of development addressed exactly this issue, the third question of Caparo test, which is the current law on duty of care, Robinson test. So the Robinson test, as I said before, is addressing the third question of Caparo test, which was the biggest problem of establishing the duty of care. In Robinson, it was argued that a precedent system had to be adopted. So in other words, the courts should look at previous cases which the facts of which applied in the case at hand, the facts of which were similar to the case that they were deciding, and accordingly consider if there was a duty of care. So instead of generally deciding what is fair, just, and reasonable, they had to look at similar cases. So Caparo test was narrowed by Robinson. Significant changes were made, and negligence as a result of failure of their duties, whether third party is injured or has suffered damages due to negligence of police. So this case was specifically about negligence of police, and the test was narrowed to not just about the police cases, but generally the test of duty of care was narrowed. Law of Reed's analysis of the correct approach today is as follows. Where there is a line of authority establishing that a duty of care is owed or not owed, the courts must follow that authority in all future cases of the same kind. In simple words, if there is a situation where duty of care was established, in the future cases, the courts should also find duty of care in similar facts. Where there is a novel case, which is possible, that there is no precedent, it's something new that courts haven't dealt with before. In this case, the courts must identify legally significant features and develop the law incrementally and by analogy with established authorities. So there can be cases where the facts may not be exactly similar to the already established authorities, but at least the courts have to identify the similar legal principles that have already been established and applied accordingly. So and when you have a problem question on negligence, this is how you should approach it. Firstly, you need to establish whether or not there is a duty of care. Do not assume that there is a duty of care, and if you are concerned with one of the traditional duty scenarios, even if it's a doctor to patient, which is traditionally should be assumed to duty of care to exist, it's no longer the case. So make sure that you apply the Caparo-Robinson test and establish that there is duty of care. After establishing that there is duty of care, you need to show that the duty of care has been breached. This is shown if the defendant's conduct has fallen below the standard expected of someone in his shoes. And then, to apply the but-for test for causation, but for the defendant's negligence has the, would the injury have come about? Discuss, and finally discuss if the outcome is too remote from the breach, the remoteness requirement. Essay question, you may also receive an essay question on duty of care. And this is the example essay question that you may receive on your exam or your coursework. Is breach of duty a disappearing element of the action in negligence? How should you approach this kind of question on your exam? The structure is the same that you should use for all the essay questions, and it follows. It is as follows. Introduction. In the introduction, you briefly introduce the issue at hand. You don't write everything you know about duty of care. That's what most of the students do, and it's a very common mistake, and make sure you avoid it. You only write what is relevant to the question asked. Make sure that you read the question many times when you write the answer, because sometimes it's very, very easy to go off topic, and you shouldn't. The time you go off topic, the time you start writing things that are clearly relevant to the question asked, that's when you lose marks. So make sure that you really are in the scope of discussion of the question asked. You will not impress the examiner by writing things that may show the research that you have done, may show that you have done a lot of reading about this topic, but is not answering the question. Anything that is not answering the question is irrelevant and should not be mentioned in the answer. So introduction is a briefly introduce the issue at hand, which is if breach of duty is a disappearing element, and why would someone assume that breach of duty is a disappearing element of negligence claim. Secondly, you need to provide arguments for and against the statement which is breach of duty a disappearing element of the action in negligence. Arguments for will be arguing that I would be arguing that breach of duty is disappearing and is no longer needed for the action in negligence, and the arguments against would say the opposite. So you make sure that you have arguments for and against the statement of the question asked, and all your arguments are backed by either journal articles, mainly. Most important is that you use the cases and the primary law, which is the statute and the cases, but you should also use journal articles and essay questions to back up your arguments. And in the conclusion, you need to sum up the main arguments and answer the question asked. Very important here to take into consideration is that your argument should be very, very clear. So everything you say in your essay should be either arguments for and or against the question asked. And make sure that you read the essay, the answer that you wrote carefully, and ask yourself if it's actually an argument for or against the question asked. Main points to consider in answering this question is the following. Duty of care is no longer automatically assumed as it was before in case of one of the established duty scenarios, so such as doctor to patient or solicitor to client. Duty of care test as per Caparo and Robinson should be applied in order to determine if it's a duty of care. So this is the case from 1954, when this was a case about doctor and patient, and the duty of care was automatically assumed, and duty of care test was not applied. The foreseeability element was discussed, breach of duty was discussed, remoteness was discussed, but not duty of care. You should consider that this was the case back from 1954, when duty of care test was less relevant in negligence cases. Now you should compare this case to the case of Darnley from 2017. In this case, the claimant was not treated in time at the hospital. Hospital admitted that they had the claimant been treated promptly, he would have made a full recovery. So the hospital was liable, but the judgment was concentrated mainly on duty of care element, despite the established principle in English tort law that hospitals owe a duty of care to their patients. What are the conclusions that we can deduce from this? The courts no longer simply assume duty of care on established duty situations, such as hospitals to their patients, and comparative Robinson tests shall be established in every case. Possible reason why this has happened is that UK is becoming a compensation culture, and automatically assuming a duty of care in all the established duty scenarios, it can open a floodgates of liability. And duty of care test is like a control mechanism that courts use to not open the floodgates of liability in this kind of cases. Important cases on duty of care to read are Donoghue and Stevenson and versus Merton that we have discussed today, but you can read a full summary of these cases on these links. Murphy versus Brentwood, also an important case to read and understand the history of the development of duty of care test and comparative test and onwards. These are the cases that you should be reading after this session. How you can find any specific information you may be looking for your assignments or for your exams on our website very easily. If you just type in the search bar any keyword that you need to research for example, duty of care, you will see all our resources, many of which are available for free, and you can read from them very easily. Now a little bit of information about us and how we can help you with your exams and assignments and tort law. At Simple Studying, we're a team of content creators, team of law students and graduates who have all achieved very high grades, and we are sharing our knowledge and experience with the rest of the students to help them achieve the same success as we did. We create simple study resources focusing on getting high grades. The most important is not that you read everything from your course, but the most important is that you have the right materials in front of you so that you can get high grades as simply and as easily and quickly as possible. And that's our objective at Simple Studying, and our platform is built specifically for that reason. You can read our notes and case summaries on these links, as well as watch our tutoring sessions. You can practice with our quizzes and flashcards on tort law to test your knowledge. It's an amazing resource for students who have exams in tort law and who have to memorize the tort law principles and cases. And finally, it's a very important resource that we provide model answers. Most of the universities do not give you enough guidance about how you should write problem and essay questions, and most of the students do not know how to correctly present the arguments in their answers. And this is a very valuable resource that you can use to learn and improve your legal writing skills. If the resources we provide at Simple Studying is not enough, you can always book a tutoring session with us, which is a one-to-one Zoom meeting where we address any issues that you may be having in your legal studies. If you need to plan your assignment, or if you need some help with your legal research, or some help to prepare for your exams, anything you may be struggling with your legal studies, we can help you on tutoring sessions. We have already helped thousands of law students to get high grades, as you can see on the reviews. And we would love you to be the next student to get high grades at Simple Studying. Please join today, and you should also join our free study groups at WhatsApp, available from this link. Thank you very much for attending this session.